Parties are always a problem for parking. My sister has parties at her house in Inspiration, and they park on half the street.
Because otherwise you can't do what she's doing. Everybody does. And I just trust her judgment, so I'll do whatever she wants me to do.
And why doesn't he just give the land for her?
So we don't have to do that first.
I mean, why does it make?
Let me know, I think you sent me that. Did you have a location where you're gonna be?
It would have been industrial.
Sure, actually. Tour the home, so I want to live here. You know, we just said it, yeah, but it's not, what's important is that she, I mean, she knows, I don't, she knows what needs to be done. I'm here, I'll help, and I'll write a check.
Still here, so far.
The study session of the Aurora City Council for Monday, February 24th, 2025 is called to order. Would the clerk please call the roll?
Mayor Kaufman.
Here.
Councilmember Bergen. Here. Councilmember Coombs.
Present.
Councilmember Gardner.
Here.
Councilmember Hancock. Here. Councilmember Drinsky. Here. Councilmember Cassaw.
Here.
Councilmember Lawson. Here. Councilmember Medina.
Here.
Councilmember Murillo. Mayor Pro Tem Stenberg.
Here. Well. Okay, there's no mayor update. Are there any issue updates? Seeing none, is there any objection to move the consent calendar forward, item number 2A through 2Q? Is there any objection? Okay, seeing none, that item number, consent calendar item number 2A to 2Q will move forward. Item number 3A, FSIR report, FY 2026 congressional directed spending. Liz Rogers. Is your microphone on, Liz?
Super duper. Thank you, Mayor and Council. Liz Rogers, Intergovernmental Relations Manager. So there's going to be some 3 parts to this report. So if you remember at the study session last time, Councilmember Lawson did read out the bill positions from the February 7th meeting. I'm happy to reiterate those or move on to the next item if Council would like me to skip that.
So that's the same ones.
The same ones that Councilmember Lawson read from the last study session.
Councilmember Lawson, what would you like to do?
I read them at the last meeting, so we can continue if there's no additional.
Very well. Is there any objection to continuing? Please continue.
So,
So, is there then discussion on any of those items, or?
if we would like to discuss those items, we can. I was just asking if you wanted me to reiterate what they were.
I don't need you to read them.
Councilmember Gardner.
Senate Bill 25077. I don't agree with an amend position. I think we should be in an opposed position. Cora is difficult to comply with by design, and like, for example, staff is saying we think it should be 5 to 10 days for everybody. I disagree with that. I think we should be providing that as quickly as possible. So I would support an opposed position because I don't support this bill at all. And I think we need to be doing more to make ourselves more transparent and accessible, not less.
Councilmember Argan.
I thought we were opposed, no? We are opposed.
We're amend.
Says amend.
We're amend.
We're amend? Oh, I'm reading it backwards. Am I reading it backwards?
Councilmember Combs.
I thought it said opposed.
So I guess my question would be the intent behind the amend rather than oppose. I know sometimes it's advantageous for us to take an amend position so that the bill ends up being a better bill rather than just coming straight out the gate opposing.
So there are some benefits to this bill. So one of them is that it further defines what media is. It gives us a little bit more time to address requests, especially when we can compile them together. And it also allows us to kind of make sure that we're doing everything we can. There's a couple of things in the bill that we did have concerns about. So the additional increased time that we would have didn't apply to media, and normally media requests are really complex and they take more time. So we would have wanted to see more time to be able to respond to the media. And then the second amendment that we would like to see is more of addressing the breakdown of costs that we would have to do and kind of understand what that means. The way we initially read the bill was that we would have to provide a line item of how we detailed cost breakdown of responding to a RCORA request. Per some conversations with the bill sponsor, this would just be a good faith one-page estimate. They're not looking for the details that we initially thought that they were, to give some context on what those are.
Okay, further questions on that? Is there any objection to continuing with an amend position?
I object.
I'll
Okay,
go with Councilmember
very well.
Gardner on that.
We will continue with the amend position.
Second item that I have to report for you are the fiscal year 26 congressional directed. Oh, sorry.
I did have questions on other bills. I
Oh, yeah, of
apologize.
course. I apologize.
Yeah, no need to reread them. But on SB 62, it says that we would not be allowed to, or that it would modify contempt of court. My understanding is that in committee, they amended the bill so that contempt is at the municipal level is preserved. So is that accurate?
They did amend the bill. However, when we had legal review of the amendments, our legal team still did not agree that the amendment satisfied our concerns with this bill. The city has proposed a different amendment. However, that has not been accepted by the bill sponsor.
And I think that that was on the contempt of court that addressed the Pueblo issue, but the failure to appear was not, issue was not addressed. Yeah.
Mayor, so the amendment that actually my office drafted and submitted to Senator Weissman was the way we currently do it in Aurora on the failure to appear. So we only charge that as a separate offense when a defendant doesn't show up for the jury trial day. So they've gone through the week before, gone to pretrial and said, the city's ready, the defense is ready, we'll be there Tuesday morning. And if they don't show up on Tuesday morning, we're having officers call their name, and then we're filing the failure to appear because there's a gamesmanship that goes on, that they wait, they try to reset the trial dates over and over again so a victim doesn't show up. So we submitted it to CML as well, so we'll see, because a lot of cities want to make sure that people aren't getting around some of the responsibility of some of the criminal offenses by gaming the system. When we have jurors, officers, victims, and other witnesses all ready to go, and then the defendant doesn't show up.
How about failure to appear for in a judge-only trial?
We haven't done that. I mean, it's only been jury trials.
All of our trials are jury trials?
No, not all of them, but not, most of the time, the defendants are going to choose a jury trial, not a judge trial.
Mayor.
Okay. Yeah, Councilmember Combs.
So how many of those have we actually charged?
I think I probably, I'm guessing, because it's probably about 3 or 4 a month. So we finally started, because we had to set up the process, because it was new to charge that offense, because we had to set up the procedure, having officers down there. I think we probably since August. So it's been a while since we got, so maybe 20.
Okay, and how many failures to appear do we have in our courts?
It's a good question. I know we have some people that don't show up on initial settings, but they get charged a failure warrant, right, for not appearing, so they can get arrested again, but we're not filing a separate offense for failure to appear.
Okay, so we're only charging 3 to 4 of these a month as a city. So do we have, because my understanding has been historically that we have actually an extremely severe failure to appear problem.
We do on initial appearances where people are not in custody, we do. But that's just the judge issuing the contempt of court, which is failure to appear. On the contempt side, they're just issuing a warrant for their arrest, not adding a separate criminal charge that they have to account for.
Okay, so those wouldn't be impacted by this bill at all?
Correct. They have not done anything about the contempt of the judge or contempt of court in this particular bill. They've just said that no municipality in the state can have a separate offense for failure to appear.
What about when we have a failure to appear, let's say somebody has a trespassing, they have a summons for trespassing, there's a failure to appear, what happens in that situation?
A couple things. A judge could issue a warrant because it didn't appear, or they could reset it. And I think it's a case-by-case basis, especially in the HART program.
Okay.
And they're looking at those, but that is not a separate charge.
It's an arrestable offense, right?
Correct, but it's not, again, we're not filing a separate failure to appear criminal offense in addition to the bench warrant because they didn't show up to court. Does that make sense? I know it's very specific, right? We have a failure to appear, it's just like an assault, right? That is the offense. So if the underlying criminal case, let's say it's an assault, and they played the game, and we're on the fourth trial setting, and the victim doesn't show up, the city has got to dismiss the underlying assault. But we still have the failure to appear offense that we can move forward on. Then we have the mandatory minimum jail sentence. I think it's 3 days or 10 days, I can't remember, that they would be held accountable for, even though the underlying charge has been dismissed.
Okay, further discussion on this? Okay. So,
Mayor.
Councilmember Combs.
Just, this sounds like actually a fairly negligible impact, and I don't support us moving forward with this bill. This bill is really about Pueblo and what happened in Pueblo,
Yeah.
which we don't want to do. We don't want to be that court.
Yeah, I think the
So I
failure to
don't
appear part
support-
applies directly to us.
take-
Liz
I
and
just
then
wanna say-
Councilmember Bergen.
I just want to say failure to appear affects all the victims that have to keep showing up over and over, and it's a disgrace and just misjustice to not.
Liz.
I just wanted to address Councilmember Combs' question on the amount of failures to appear. So we did run some data with this, and from 2021 to 2024, we had 21,538 cases of failure to appear.
And how many of those were on traffic charges and juvenile charges?
We don't
What
have the
would-
breakdown of that. Those are all for criminal
and jail.
cases.
And those were not failure to appear actual offenses. Those were just the times that people failed to appear. And I think one of the things that the city's perspective is we'd like to not have that bill because we have no, why would anybody show up for jury trials? We have that threat that they're going to have that other offense if they don't show up for a jury trial.
Right.
Further questions or comments? Okay. Is there any objection to moving forward? What are we at, amend? Are we, we're in opposition?
Because of our amendment, because our amendment did not get accepted, so we're
Okay, so
opposed.
we're opposed. Any objection to being opposed to,
Object.
what's it, Senate Bill, what number is it?
62.
62.
That's right.
Senate Bill 62, okay, so we'll maintain an opposed position on that.
Are there any other questions on the legislation from the 7th?
Mayor.
Yeah.
So then on House Bill 1147, I have some concerns, and maybe there are some questions that can address these. Primarily, there are a number of offenses that we're required to be tracking for the consent decree that we haven't tracked, and that we're not tracking the trespass, failure to obey, and disorderly conduct. And so I'm concerned about whether or not we're setting ourselves up to be more at odds in relation to the consent decree and those consent decree requirements as we're taking such a vehement opposed position to this bill.
So, if I may, Mayor?
Please.
So, Mr. Batchelor and I have talked to our monitor, Jeff Schlanger. He's aware of this bill. We are, from my knowledge, Jason, I don't know if you disagree, we are keeping statistics on those offenses. But I think this bill, I think most people think that it's targeting Aurora. And so that's, I think, one of the questions that keeps coming up.
And so just in relation to kind of the disparate impact question that's relevant to the consent decree, what are the conditions under which an officer decides that an offense that's both a City of Aurora offense and a state offense gets charged in the City of Aurora instead of in the state courts?
Great question. So generally, if all of the offenses that an officer wants to charge somebody with can be filed in the municipal court, they're filing them in the municipal court. If there's an offense, whether it's another misdemeanor that we don't have in our city code, or if it's a felony offense, then then they go to the county, and the law of joinder requires everything to go to the county. We're not splitting the filing. If there's any charge that goes to the county, all of them go, nothing in the municipal court.
And how are we tracking then the impact? Like, are there disparate impacts that could be implicated in the consent decree on the basis of race in those filings in municipal versus state court?
I don't think that has come up. I don't think there's been a knocking, blow to the consent decree monitor that's happening, because he's understanding this question has been asked by him, is how are you all making the decisions, which I'm sure is going to come up in the legislature as well. How do these decisions get made? And that's it. It's if there's one offense that goes to the county, it all goes. And so it's based on the conduct that the officer views.
Sorry, one more question. So CCI and the counties support this bill. Right now, they jail any of our defendants that are there for more than 30 or more than 3 days. Are we going to be tempting them by continuing to implement disproportionately higher sentencing, which we do, to start charging us for the beds? If our counties are saying, we don't want this kind of sentencing, we would like the sentencing to be equal across the municipalities in our counties, and we're saying, nope, too bad, we're going to keep doing this, like, are we going to start getting charged for beds?
So I think the reality is, if this passes and it sustains any legal challenges, what's going to end up happening, the criminal offenses that would go into the municipal court, we're going to file into the county court, just like domestic violence cases starting July 1. And they're going to be having an increase in their budget. And so we're not going to be handling them in the municipal, the criminal office. I'm talking about traffic and other things, but I've been talking to other city attorneys in other cities, and that's the general belief, that if this happens and it gets to sustain itself for legal challenges, we're just going to use the county courts. And we're probably going to have the same pushback that the counties have had about us with domestic violence cases, that we don't have the judges, we don't have the DAs. Well.
Okay. I think that certainly, I like the fact that we, exercise our home rule discretion in terms of having tougher sentences on certain issues, like retail theft. It's a big problem in this city. And I believe that having those tougher sentences is a deterrent to retail theft, and I would not want to give that up.
Mayor,
Councilmember Coombs.
just, again, in light of the disparate impact issues noted, the relationship that we have to the counties, I do not support our opposed position, and I will testify in support of this bill at the legislature.
Mayor, can I say something? And I heard
Councilmember
Councilmember,
Lost.
You don't go in before the committee like you have before and state, well, I don't agree with the Pfizer committee, that you're going on your own behalf. So I hope that that's in your testimony.
Clear.
I've been very clear that
You
I'm
didn't do it
testifying
last year.
on behalf of myself
You didn't do it last year.
every time.
Because I saw you testify. You didn't do it last year.
I say it every
No,
time.
you
I'll
didn't.
get the recording.
Yeah, you can get the recording, but I know that you said, we don't agree with the Pfizer committee. If you're going on your own behalf, you need to state on your own behalf, not what the Pfizer committee is doing.
And I'll say we
to
will litigate.
clarify.
We will litigate this if in fact it does pass.
To clarify,
No,
with the city
clarify
attorney, if I state at the beginning of my testimony,
That you don't
I'm
agree.
speaking on behalf of myself, are there any other restrictions on what I may say?
No, I mean, so I would just say at this point, it would be that the majority of council supports the position of the city. I disagree with that, and then you would state what you're doing, because this has now come up at the full.
City attorney, can I just ask a question?
Yes, ma'am.
If she goes before the committee and states, because majority of some of our council don't agree with the Pfizer committee's position, is that incorrect?
Yes.
Okay.
I've never
Thank you.
said the
Yes, you-
majority of
you-
council
but you
disagrees.
have
I've
did
said
it.
I disagree with the
You have
majority of
did it,
council.
Councilmember
Okay.
I can
Jones. So you're
say.
sitting here lying.
Okay.
Because I've heard you testify.
Liz, okay, so we will continue in opposition
Yes.
to this bill. What's the next one?
If any other questions on any
Are
other
there any other
legislation?
questions? Okay,
I
seeing
still have two
none.
more items, I promise.
Okay, please.
Sorry, this is a long report today. Okay, so the other part of this is the committee also discussed our federal directed spending request for fiscal year 26. So we will have 3 this year focused around public safety. The first one is fire apparatus for a ladder truck. Second one is a flashover simulator, also for our fire department. And then the third one is our public safety drone program, which we will request drones. Happy to go into detail on those. The other part I want to mention is that we have received word today that our Senate offices would like us to resubmit our fiscal year 25 requests that have been approved in case there is a year-long continuing resolution. If a year-long continuing resolution occurs, we will lose all of the fiscal year 25 CDS requests and we would have to resubmit for them anyway. So just want to let everyone on council know these requests have already been approved. So we're just going to resubmit them as a just in case.
Okay,
One more thing, if there are no questions
please.
about that.
Okay.
Are there any questions about the
Any questions
congressional
on
directed
this?
spending?
Okay.
Okay, last thing. So last time at study session, there was some discussion on the report not being as accurate due to the scheduling of when Pfizer was versus when the study session was. So I've talked with legal, and our workaround for that is in the backup. The backup documents will be the Intergovernmental Relations website, which is always up to date with the most accurate bill positions. And in this way, you know, if we have a Pfizer committee meeting on Friday, we can share with the next Monday what those positions were and get that information to you all, instead of having to wait that 2-week cycle.
Good. Anything else, Liz?
Nope, that's all.
Any questions for Liz? Okay, thank you very much.
Thank you.
Okay. And 3C is request has been pulled. Okay. We will encourage members of council to attend public invited hearings.
Which starts at 6:30.